Okay. A warm welcome to each and everyone today who have made the effort and time to attend our seminar, both locally, regionally, and internationally. I greet you all in the name of peace. Thank you for registering for this, the second seminar of our newly established Muslim Personal Law Unit under the auspices of the Center of Legal Integration in Africa, which is located in the UWC Law Faculty's Department of Private Law. Attorney Ismail Mohammed, a few months ago from the United Ulama Council of South Africa, presented our inaugural lecture, where he, in a nutshell, espoused the view that law should be enacted that both recognizes Muslim marriages and regulates its consequences. Now, this theme is elaborated today from a gender perspective. So on behalf of the Dean of the Faculty of Law, Professor Jacques de Ville, our Head of Department, Professor Sue-Marie Viljoen, the Director of CLIA, Professor Anthony Diala, and the members of our unit, it is indeed our great pleasure to welcome our guest speaker, who is no stranger to this faculty and the Western Cape community at large. While she has a long and illustrious CV, mindful of time, I will keep it brief. So Siham has held in the past and currently continues to hold many prestigious and community portfolios in the Department of Justice, the National Lawyers Association, and the South African Women Lawyers Association, all of which reflect a passion for women's rights, human rights, land justice, and community activism. Attorney Siham Sihamai is an alumna of this faculty, and during my time as dean many years ago, was appointed as director of the UWC Law Clinic, where she practically trained and taught law students and candidate attorneys within a clinical law environment with the aim of inculcating principles of social responsibility and social justice. She's currently director of the Women's Legal Center, a feminist organization that advances women's rights and equality through strategic litigation, advocacy, education, advice, and training. The topic of today's seminar is the position of the Women's Legal Center Trust on the recognition of Islamic marriages in South Africa. Now, the August 2022 Constitutional Court judgment 2 years ago, whilst affording interim relief, gave Parliament 2 years to promulgate legislation recognizing Muslim marriages. As this time is soon running out and national elections are once again upon us, which in the past has usually been the time when we see some or other progress with Muslim marriages in an effort to boost votes, President Cyril Ramaphosa has very recently signed into law the Divorce Amendment Act. So in a presentation today, Attorney Samai's talking points will focus on these most recent divorce amendments and why the Women's Legal Center agrees with it, briefly touch on the marriages bill, and if we're lucky, given that they haven't filed their responses as yet, may disclose the Women's Legal Center's trust strategy. So without any further ado, I hand the floor over to Sia.
Just thank you very much, and thank you to UWC for inviting us. It's wonderful to be back and to be able to be at the university again. And I hope it's going to be a fruitful discussion. Just for those that don't know the center, I mean, we are African Feminist Legal Center that advances women's rights, equality, and using the tools such as litigation and advocacy to promote substantive equality. And it's also done through an intersectional lens. Just with regard to, you can move to the next slide. This presentation explores for us the transformative journey and the implications of the Divorce Amendment Act, which is a significant step for us towards rectifying the historical discrimination against Muslim women in South Africa by granting their marriages legal recognition and equivalent rights as those accorded to other marriages under South African law. So additionally, in addition to the divorce amendments, The Marriages Bill, which was only went out for public comment on the 13th of December 2023, addresses the legal recognition and regulation of unrecognized marriages, including Muslim marriages. And through the center, this presentation underscores the constitutional necessity and social implications of these legal changes. It is also explores the regulation of these marriages within the broader framework of the Marriages Bill and the role of the court cases and advocacy in pushing for these reforms. Maybe we can move to the slide. Yeah, so the topic could be ensuring equality, legal recognition, and protection of Muslim women in South Africa through an intersectional lens. We can move to the next slide. And the next one. So the next slide, the non-recognition of Muslim marriages in South Africa has historically placed women at a significant disadvantage, particularly in the context of divorce and inheritance rights. The center has been instrumental in advocating for change, culminating in the landmark ruling by the Constitutional Court in 2022, which found that the lack of recognition is unconstitutional, and it mandated legislative reform. So this paper will delve into the legal journey leading to the divorce amendments, as well as the implications of the Act on women and the broader legislative context of the Marriages Bill. So WLC, context and background. The WLC has been at the forefront of litigation efforts to secure the legal recognition of Muslim marriages. We successfully represented women in the landmark Constitutional Court case, resulting in the court order. And so this decision, rendered in June 2022, aims to extend legal remedies to women in Muslim marriages. And over the past 4 years, the Centre has been actively involved in the legislative development efforts by the South African Law Reform Commission. And I want people to know that for the past 4 years, there has been many legislative reforms that was recommended, and one of it was the South African Law Reform Commission, which we also which looked at a single marriages bill. Then Department of Home Affairs came, and they then brought in an omnibus, which was pulled back, and then in December, the actual marriages bill came in that looks similar to the single marriages. But be as it may, it's out for public comment. And so our litigation efforts have also yielded significant victories over the years in cases involving the rights of women. So for decades, Muslim women in South Africa have faced legal challenges. This lack of recognition meant that upon divorce or upon death of a spouse, women were not entitled to legal protections available to them. And this is in relation to claims for inheritance, maintenance, and equitable asset distribution. And the WLC identified these challenges early and has been actively involved in litigation. So the Centre, just quickly, applies an intersectional feminist approach in its strategic litigation, and it has dedicated focus area that speaks to relationships and families in South Africa in their diversity and are legally recognized, respected, and the rights of women in those relationships are protected. So Muslim marriages are not just the only case. We've also dealt with domestic partnerships, which is a key focus also of the Women's Legal Center, as well as African cultural marriages. So the Constitutional Court ruling, the court declared the continued non-recognition a violation. And so the court ordered government to amend existing legislation, which is both the Marriages Act and the Divorce Act, in dealing with, firstly, Divorce Act dealing with dissolution, and the Marriages Act to deal with the broader framework of marriage. So the key findings of this ruling was that various provisions were inconsistent, and it held that the Divorce Act are unconstitutional as these fail to safeguard, firstly, the interests of children of other marriages. On the dissolution of the marriage, it fails to provide for the redistribution of assets, and also it fails to make provision for the forfeiture of patrimonial benefits on the dissolution. And so we all know that women and children at the end of the day are discriminated in relation to these provisions. So the legislative response. So following the Constitutional Court, the Divorce Amendment was introduced and signed into law recently. And so the Act allows women in their marriages to initiate divorce proceedings in civil courts, ensuring they do not have to rely on the religious decrees, which may not provide equitable relief. And so many of the ulama or persons might have a challenge with this, and there might be a question that comes out of it. However, we will be able to indicate why we are saying that without a talaq and without a fasak, you can still go to court. The amendment empowers courts to make decisions on the just and equitable division of property acquired during the marriage. So the provisions of the Divorce Amendment Act that we're looking at is the definition of Muslim marriages, which is now incorporated, protection for children, safeguarding the interests of, and this is also for all religious marriages, because we also know that Hindu marriages is also not recognized if they are not married civilly or in terms of so if they're not married in terms of the Marriages Act. And then we're talking about protection for children, safeguarding the children and minor children of these marriages. One of the challenges that we have is that with the talaq and fasak, it never goes to the family advocate. And so we have to deal with the issue of contact and care, which is within the Act. Then with regard to the asset redistribution, providing for equitable, not equal, equitable distribution of assets upon the dissolution, because we have seen many women, I would say, on the street because of this land recognition, and they cannot claim any of the assets. One, this is a very, very important provision for us, which is forfeiture of benefits, which ensures fair forfeiture of patrimonial benefits on marriage and dissolution. There are many other provisions, which now includes, for example, polygamous marriages and how that dissolution also occurs. So all the clauses of the Divorce Amendment Bill were accepted, except Clause 6, which dealt with a retrospective application of the amendments. So this clause aimed to extend protection to marriages dissolved religiously in the past and ensuring that all affected women receive the necessary legal remedies. So, however, it was not accepted, and we made serious submissions around retrospectivity, and I would say maybe there is another case that is waiting. Why we support these amendments? The Constitutional Court has highlighted the ongoing discrimination and emphasizing that the failure of these marriages is rooted in deep-seated prejudice, and I would also say patriarchy. The recognition of Muslim marriages was envisioned with the advent of the constitutional dispensation in 1994. But I know that Professor Mosa will most probably say, no, it didn't start there. There was 1956 when there was an attempt, and I would say there's 300 years of colonialism, which none of our marriages, none of the Muslim marriages were recognized. So despite this, successive governments have failed to implement necessary legislation and also protect Muslim women, perpetuating the vulnerability, especially upon the dissolution. Muslim women, upon this divorce through talaq, often find themselves without any propriety rights, leaving them destitute and without legal recourse. And I think I need to be able to just highlight Muslim women had a triple form of discrimination. Firstly, in this country, Muslim women were never recognized. They could not even sign documents. That, in addition to that, they were discriminated based on their gender, their religion, as well as their race. And so there were many cases that were brought to be able to ensure that they obtained their rights in terms of the Constitution. So this situation is exacerbated by patriarchal attitudes under the lack of statutory protections, such as those provided in the Divorce Act, and the involvement of the family advocate. It is crucial to address these inequities to ensure that Muslim women are afforded the same legal protections as their counterparts in civil customary marriages. So the economic and social considerations, the economic and social realities faced by Muslim women necessitate legislative amendments. Assets acquired during Muslim marriages are typically registered in the husband's names. We know this is a historical fact in relation to South Africa. So it's not just an issue for Muslim women, it is in cultural marriages, it is even in terms of the Marriages Act. This situation is discriminatory and it's unjust, and particularly given that women often contribute significantly to the household through unpaid care work and other non-financial means. And all of that is not recognized. The Constitutional Court's recognition of the discrimination underscores the legislative measures that allow for equitable distribution and forfeiture of benefits. Such measures are essential to protect the economic rights and dignity of Muslim women and to ensure that they are not left destitute. Specific provisions, which I will just go through quickly, of the Divorce Amendment Bill, which I've discussed already, was the definition of Muslim marriages that were looked at, which was concluded in terms of the tenets of Islam, the dissolution of Muslim marriages, in this alliance with the Constitutional Court's order, the rights of children, because now the family advocate will be able to look at contact and care, and then also, in addition, the distribution of assets, finally, the forfeitures of benefits. All of these clauses, which was all the interim relief that was granted by the court in 2018, was all taken up into the Divorce Amendment Act. And so it was accepted in the divorce amendments, except Clause 6, which is the retrospective application. We strongly supported the principle behind Clause 6, which sought to apply the amendments retrospectively to address historical discrimination faced by women. It was not accepted, but this clause would have extended protections to marriages dissolved religiously in the past and ensuring that all affected women receive the necessary legal remedies, because we do know that the interim relief that was granted was only up until the 14th of the day that we launched the particular case, which was in 2014, in December 2014. And so we need 14th of December 2014, 15th of December 2014. And so that remains the particular cutoff. So then in addition to that, they have now also, because they also declared the Marriages Act unconstitutional. And we have to admit that we knew that the state would not be able to comply by 2024, June 2024. And I will speak briefly about the court case, but just to be able to say that in terms of the Marriages Bill, it's pushing for a legal framework that accommodates different types of marriages. So, Professor Mosa, you have been on various structures. We are now back to the single marriages. Because we assumed with the omnibus that they would actually make provision for each and every marriage. So, utilizing its history in significant legal battles, the WLC aims to promote reforms that ensure equality and recognition across all marriages, emphasizing the necessity of an intersectional feminist approach. So it's very important to note that Muslim women, they live in South Africa, which was dominated by apartheid, and we have colonial history. So, in addition to being married, they also have the other triple form of discrimination. And that is what we are talking about when you speak about the intersectional approach. We need to be able to situate those women where we find them. And so the layered discrimination faced by women at the intersections of gender, race, and religion. So the key submissions that we have made in terms of the marriages bill, which is the marriages requirements and the contractual obligations, advocates for a clear, equitable marriage requirement, aligning them with constitutional standards and international human rights. This includes proper consent, minimum age, and fair contractual obligations during and after the marriage. Property and maintenance rights, highlighting a gap in legal protections. The submissions argues for the bill to include provisions that ensure equitable distribution of marital property and maintenance rights, post-divorce maintenance, which is so critical. Not nikah, not nafaka, but we are talking about post-divorce maintenance for women, similar to the protections in other legally recognized marriages. It's very important. Um, Contact and care of children. The submission calls for the explicit provision concerning rights and responsibility, and also ensuring that the welfare and the rights are upheld regardless of the parents' marital status under religious laws. And then in addition to that, it will also look at the minimum age of marriage. We need to ensure that the Children's Act and the various other legislation, we need to be able to ensure that Muslim children or Muslim families need to adhere to the age of 18. The WSO also emphasizes the need for Muslim marriages to be integrated into a national legal framework addressing discrimination and inequalities. This involves modifying existing laws and policies to respect the unique aspects of Muslim marriages, aligning with the broader goals of the Marriages Act. And so the general recommendation that we've made was that such as the need for a comprehensive definition of marriage that reflects the cultural, religious, and personal dynamics of South African society. The WRC calls for the legislative clarity that not only adapts but reimagines existing frameworks to accurately represent the population's diverse realities. So, Parliament, on the president, when the amendments came through, the week before, on the 2nd of May, Parliament brought an application for an extension and seeking a 24-month extension on the suspension of the declaration of invalidity for the Marriages Act to address their failure to recognize Muslim marriages. Sorry, I put in my notes Divorce Act, but it's the Marriages Act. And so the approaching deadline of June necessitates this request to ensure thorough public consultation and legislative refinement. But I have to admit, it has been a very, very tight deadline. Literally, it was served in December, and submissions had to be due. We submitted our submissions last week. Key points from the application: the complexity of the marriages bill and the concurrent election cycle. But we all know elections has always been an excuse in finalizing the bill within the original timeline. The ongoing registration of Muslim marriages by the Department of Home Affairs and and also in addition to that, extending the deadline, which would not prejudice the public. That is what they are saying. But we have to note that currently the interim measures is exceptionally unclear, because they have indicated that the marriage can be registered in terms of the Recognition of Customary Marriages Act. So it's very unclear what the current situation is since 2022. We have written numerous correspondence to Home Affairs to be able to advise us what that interim provision is. The additional time will allow for more inclusive approach to potentially revise provisions for other religious and civil unions, which is Hindu marriages and etc. And also, in addition to that, the potential consequences of an extension, no extension granted could lead to non-compliance, possibly with the court's directive, it would, undermining the rule of law and resulting in legal uncertainty and potential discrimination. However, if the extension is also granted, in addition to that, by default, it can also mean that the Marriages Act should apply, which means all its particular provisions. And I think that that is what Parliament is trying to avoid. If the extension is granted, ensures continuation of interim measures and thorough legislative process, preventing any disruption or prejudice to those that's affected. So for us, the Divorce Amendment Act represents a critical step forward in the legal recognition and protection of Muslim women in South Africa. It's a testament to the perseverance of the advocacy groups like the WLC, including the Muslim Women's Network and various other structures, to be able to ensure we have equality under the law. Further legislative and societal efforts will be necessary to continue this progress and to ensure that all citizens are protected and recognized equally by the South African law, and also by recognizing and regulating all marriages in a fair and equitable manner. The legislation upholds the constitutional principles of dignity and equality and freedom. And this approach not only meets the constitutional and international mandates, but also addresses the practical needs and the rights of individuals within the marital institution, ensuring that all stakeholders are protected and recognized under the law. So I'm going to open it up with regard to the Women's Legal Center. Our approach would obviously be halfway. We have submitted our submission, so you can see in all probability we will abide. However, we do believe that the period requested is too long. We also believe that in addition to that, that possibly, and we are still speaking to council to see whether or not we can have a structural entity, a structural form of order, because it has been 2 years, more than 2 years. There has been many bills and acts that have come out, and the challenge that we do have is that women, Muslim women, are continuously being disadvantaged. If we made the decision to oppose, and maybe I don't know if many of you know the Ramahovi case, which dealt with the polygamous marriages and also the in customary, and where the state has not did not amend the recognition of customary marriages. The court indicated that enough time was given, and then the default position was what was asked, and it became the amendments. The challenge that we're sitting with now is this: the interim relief that was granted was primarily around the dissolution. And so it didn't really deal with in-depth the marriage and how that had to be regulated. And like I've indicated, the Home Affairs interim relief was to use the recognition of customary marriages. So that remains a particular challenge. So therefore, we need to be able to look at this marriages bill, because it doesn't just comply with Muslim marriages, it's all marriages, and that there are many challenges even within the recognition of Customary Marriages Act in terms of that also have to be addressed. And so we will most probably, in all probability, abide by the request, obviously putting in systems to be able to ensure that there's accountability. I'm going to leave it there because I know that people must probably want to ask questions, and I can open the floor. Thank you.
Okay, thank you very much, Shyam, for that presentation of the status of the Women's Legal Center Trust with regard to a number of matters, and the main focus being the Women's Legal Center Trust case that was initially at the Constitutional Court, went to the High Court, Supreme Court of Appeal, back to the Constitutional Court, each of these courts giving 2 years. And the
Yes.
last 2 years is ending very soon, and now they're asking for another 2 years. So definitely, time is going on, and many Muslim, especially females, they are not finding this to be something which is acceptable. So it was very interesting to hear the in-depth analysis of what the Women's Legal Center Trust position is concerning the matter, as well as the position concerning the Divorce Amendment Act, or the bill, basically, which was signed now recently, as well
Yes.
as the Marriages Bill. Right. So, without any further ado, and due to the limited time, I do know there might be very much burning questions. So I will then take it one at a time. Are there any persons who'd like to ask any questions? Alternatively, you could also put it in the chat box, and I can then read it out to Siam. Or you could just basically, by show of hand, the virtual hand, if you have any question. Hussein Sanjay, can you just assist me? Am I all right? There's a question.
Yeah, am I live, Munir?
Yes, go ahead, Ashraf, go ahead.
Assalamu alaikum. Thank you for that in-depth analysis and making your time available to give us some sort of input. I have a scenario, and I know we pressed for time, but in terms of the redistribution
Yes.
that you've alluded to, as well as in the Concord matter, if I just want to ask you a quick breakdown of something. If a couple, they've been married and they get divorced, the wife has an excellent job, the husband has an excellent job, he has a house, she has a house. Could you just identify or paint us a picture of how the redistribution would work? Because I know they're looking at equitable redistribution.
Just an equitable redistribution.
Yeah. So if you could just elaborate on that for me, please. Thank you.
Well, I don't know if you know, it's a normal divorce, and so you will obviously bring evidence in terms of what would be just and equitable in terms of the division of that particular estate. So we all know that, for example, if a woman's property is hers, however, there's different forms you will be able to bring that particular evidence to, in terms of that actual divorce, and then the court will do the redistribution in terms of what they think is fair and equitable for both parties. I don't know if it's sufficient, but it's a normal divorce. And you will just, each party will have to indicate what is it that they want in terms of the assets, and the court will then decide. Because remember, it's not in community of property, it's not 50-50. And so more times than not, the women will have to prove, for example, the unpaid care, etc., etc. And if they want, for example, some of the Islamic rights, etc., etc., it can be brought in the particular divorce. But that divorce is also not dependent on them getting a talak or fasak. I don't know whether or not that answered you.
Yeah, I think that answers the question. Shukran for that. Thank you for that, Shyam. I see there's another question on the chat group, and the question is it true the Imam told the wife she can only get a divorce if she withdraws the application for a protection order? I don't know the context. This is from Winifred Sile Mokoko. I don't know if that is enough information.
No, listen, there's many, I don't want to say, I don't know if there's ulama here, but there's, over the years, I mean, I've only been at WLC for 7 years, but I've dealt with Muslim marriages since I've been at the law clinic at UWC. And so the challenge has been for women to be able to get a fasak has been horrendous. And then you have those that do get it. But for those that came into this WLC and also various law clinics, and so I don't know the context. I can't say the veracity of it, but we have had very weird things that were said by those that were supposed to provide for talak or fasak. And so I can't obviously say yes or no because I don't know the context, but we have had many reasons, women that were sent back to their husbands to reconcile, notwithstanding domestic violence or even any form of economic abuse. Whereas the domestic violence, we encourage women, all women, Muslim women, all women to go to domestic violence courts for any form. And I do think that those, the ulama and those that are dealing with these relationships and divorces, etc., should continue if there's any form of abuse in that particular relationship. It's something that we encourage. They must go to domestic violence court to be able to ensure there isn't any form of other economic or even so any imam or priest or any person that says that to a woman, sadly, should not be one.
All right, thank you for that, Shaham. I see there's a hand up by Shireen Ibrahim. Yeah, maybe you can just introduce yourself and thereafter pose your question to Shaham. Thank you.
Assalamu alaikum. My apologies for tuning in a bit late. I was in 2 meetings. I'm Shireen Ibrahim, and I'm engaging in my personal capacity. I also manage the Family Advocate Services for the Western Cape. My concern is that the Muslim the Muslim clergy who engage with women, men, and children around issues pertaining to marriages, the status of marriages and divorces, often lack the knowledge of civil law, and as such make arrangements with regard to what they understand to be Islamic law, and sometimes that advice is used to the disadvantage of children and or the women, and in some instances the men. For example, also our courts are not, the lower courts in particular, are not au fait with Muslim practices and make assumptions around what that is. For example, we have a Muslim woman who gets her fasakh, and the fasakh is only limited to the status of marriage, to the status of their marriage, and not at all to the patrimonial consequences of their marriage or their maintenance. And she goes to the maintenance court and to the high court as well to secure maintenance and deal with the further consequences of the breakdown of their relationship through a Muslim marriage. And some of the defenses that are used is that the marriage was terminated, and as such, there should be no further order given as to the remainder of the issues, because there is some unwritten agreement with regard to the children and the division of the joint estate. And I think Islamically as well as constitutionally, we are prejudicing such women. So I would suggest that our clergy also have some understanding of civil law. They don't need to be practitioners, but they need to have an understanding around civil law or make decisions that their written agreement with regard to fasaks or talaks do not incorporate, make it clear that it doesn't deal with maintenance, care, contact, or patrimonial consequences. Thank you.
Thank you for the question, Shireen. Hand over to Shyam.
No, I think it was a comment made by Advocate Ibrahim, but she knows because she is the family advocate in this province. And those issues are normally dealt with after the fasak or talak. And it's quite problematic, especially for the family advocate then to also deal with those particular issues in relation to contact and care. But in addition to that, going to the maintenance court for even post-divorce maintenance, any form of maintenance, remains challenging because it's because of the non-recognition. And hopefully the marriages bill will be able to also deal with those particular issues because, like she said, there's only a divorce and only the talak or the fasak, and then there's absolutely no enforcement. Nobody deals with the consequences of that Islamic divorce, and women at the end of the day is left destitute, and children.
Thank you for that, Shyam, and also for the comment made by Advocate. Are there any other questions? You can just raise your hand, and then thereafter give your name, or you could put the question on the chat box. Yes.
No, I'm just looking at the chat.
Okay. All right. It then seems that your presentation was quite very informative, and many of the questions that might have been posed have been answered either via the slides or through your presentation in the notes. Yeah, because many people were looking quite forward to this presentation here today. It has even struck some interest from some other countries like Indonesia, UK, and even Russia. The invitations has gone out to look at how Islamic law is being applied in a country like South Africa as a Muslim minority. So once again, we thank Sister Shyam Samai for that very informative presentation. As this is the Women's Legal Center Trust, and she is a director of the Women's Legal Center. And this has also basically sparked debates within the academic community. There's many articles written on this subject. The subject matter. There's many bills of parliament, as has been referred to, omnibus, the single marriage statute, the marriages bill, bills by political parties like Jama'ah and so forth. And definitely this is a very interesting topic, and it's good to have someone of a stage stature over here. Before we do the closing, I do see there's another question here in the chat box by Sumaya Parker. It says, now what is said is so true. How do a divorced woman then go about claiming for maintenance for the children, as it can be costly to pursue this privately? Maybe we can just answer that question.
Well, the maintenance courts are available. It is supposed to be free of charge. There is maintenance officers. And so if you are divorced and your children are not taken care of, you need to go to the maintenance court to be able to ensure that. What I have spoken about was spousal maintenance, maintenance for women post the nafka period. And so we know also men don't nafaka women. Can they go to the maintenance court? Can the marriages bill regulate this? And so we need to be able to look at this, like I said before, through a lens where we find Muslim women, which is in South Africa and with its legacy. And how can we support them? So the maintenance courts, no matter what religion, whether or not you're married, divorced, living together, single person, the responsibility of both parties is to ensure there's maintenance. So it shouldn't be costly. You can even go to the law clinic at UWC, the law clinic at UCT, Stellenbosch, that will do it free of charge to be able to ensure that children get maintenance. What I am challenging is the issue of post-divorce maintenance, and whether or not our courts will be able to accept that.
Okay, thank you very much for that, Shihan. If there are no further burning questions, in the chat box or via raising of hand, right? Like with permission of the members of the centre, I'd like to thank Sister Shihan Samai for taking this opportunity as being the director of the Women's Legal Centre Trust to give us some insights concerning what the position of the centre is concerning the state of affairs for especially Muslim women in South Africa. And they were the forerunners with regard to this matter of the recognition of Muslim marriages within the South African legal context. In the previous webinar, we had the United Ulama Council of South Africa, and they have given their view. And today we have the Women's Legal Centre Trust, as Prof. Najma Musa stated early on, giving the status of affairs within the centre, right? And this webinar series, it falls under CLEAR, the Centre for Legal Integration in Africa, and we'd like to the HOD Private Law Department, Professor Sumari Viljoen, as well as the members of the Muslim Personal Law Unit, which falls under the CLEAR, and all parties that were part and parcel of making this event here possible today. The technical team, Kay Sapto, Glanda Modane, and the members of this unit that is now Dr. Buli, Prof. Musa, Dr. Latifa Mani, and Mr. Hussein Sangay. And everyone, especially who had come from around the globe, the various countries, and locally here to listen to this presentation. So once again, Samai, thank you very much for taking time out, and it was really an honor to have you here today. So with that, Shukran, I bid you farewell, and hopefully we'll get you back in future again when there are further developments in this regard, and hopefully you will again accept our invitation as you have done this time. Thank you very much.
It is my alma mater.
Yeah, yes, definitely. Thank you very much, and thank you for everyone.
Okay.
Good afternoon.